You've been on our show and you said you thought that 8 games was kind of the sweet spot. You also had this tweet and you told us this, but let's take a look at it. Again, the rationale for no suspension, higher burden of proof that has been agreed upon, no live accusing witness testimony, no opportunity for cross-examination, and what we were talking about a little bit there, the disparate discipline doctrine. Take us through that and kind of, you still feel 8 games is kind of the sweet spot between where the league thinks they did enough and where Watson's people may accept?
Well, 8 games is my cynical, prediction as to where the judge may land based on her desire not to be reversed on appeal by Roger Goodell and to strike a balance where both sides could walk away without taking appeal. I mean, as I've stated on other podcasts and other programs, I believe the burden of proof here presents a serious obstacle for the National Football League, because I wouldn't want to be the plaintiff's lawyer who takes a civil litigation case and tries to win by a preponderance of the evidence without putting on any witness testimony. If I had to rely on, summaries of transcripts and notes, I wouldn't have much of a case. And one of the cornerstones of our adversary system is the right to confront witnesses. It's called the Confrontation Clause of the Sixth Amendment, I believe. And the ultimate truth serum in our adversary process is cross-examination, the opportunity to test the veracity of the accuser's statements. That opportunity is absolutely missing from this proceeding because the league interviewed these witnesses and accusers in their conference rooms under conditions created by the National Football League. And I can guarantee you, Jeffrey Kessler wasn't in the room. Deshaun Watson's legal team wasn't in the room. And the NFL could craft a narrative and say that this is our transcript and ask a whole bunch of leading questions and create a sort of a one-sided narrative that's not tested on cross-examination. And if I'm a judge, Sue Robinson has been was a federal judge for more than 25 years. She's instructed juries on what the preponderance of the evidence standard means in actuality. And I expect her to hold the NFL to that standard. And I think in the absence of a criminal conviction or, written documentary evidence where there's an admission by Deshaun Watson, that poses a real danger to the NFL to take cases that have not completed through the litigation process or the criminal justice system and present them as sort of incompleted adjudications and try to arrive at a determination and convince a federal judge that something happened here when you're not bringing the accusing witnesses to testify live in open court before this judge, where Jeffrey Kessler or Watson's attorney have the opportunity to ask questions on cross-examination. So the burden of proof, the absence of live witness testimony, and the disparate discipline issue, which is replete through the NFL's history in regards to how it's treated Dan Snyder, Haslam now, Robert Kraft, Jerry Jones, and who knows who else is out there, maybe the Houston Texans. So rather than subjecting league officials to a higher standard, which is what the personal conduct policy actually says, that these officials are held to an even higher standard than the in actuality, they skate free and clear without so much as an investigation. That cries out for selective enforcement and disparate discipline. And when you add all these elements, the selective enforcement, the absence of live witness testimony or cross-examination, and then burden of proof, which means that it's more probable that something happened than it didn't happen, more likely than not. How can you prove that if you curate a narrative out of the NFL's own internal notes that Kessler and Watson's legal team, Rusty Hardin, if he's even in the room, didn't have an opportunity to test on cross-examination for bias, for veracity, to try to poke holes in the witness's story? Without that opportunity, I'm skeptical that in real life, the burden of proof on a preponderance of the evidence standard could ever be met short of a criminal conviction or an admission by the defendant. And we have neither here, presumably.